And thank you for joining us this morning for today's webinar. My name is Ben Hawkins. I'm the Policy and Communications Manager with AMCA Australia, and it's my great pleasure to welcome you today. Before we get into the formal presentation, I'd just like to, as we always do, acknowledge the traditional owners of the land wherever it is that you find yourself. For me, that's the Gubbi Gubbi people in southeast Queensland, and I, of course, pay my respects to elders past and present. Today's webinar is on unfair contract term protections for small business. The changes to the legislation are going to result in more businesses covered, more contracts impacted, and stronger penalties for those who contradice the Australian consumer law. I know there's a lot of interest in this from AMCA members, and it's something that the AMCA, along with others have advocated very strongly for a long period of time. So we're excited that that this has come to pass, but obviously it also poses some risks as well, some protections. So with that in mind, we're very fortunate to have Michael Rochester, who's a partner with McCullough Robertson Lawyers, join us today to present on this topic. Michael is a very experienced construction lawyer with expertise in this area. So we're very grateful for your time, Michael, and obviously very grateful to McCullough Robertson, who continue to support the AMCA and our members over a long period of time now. Before handing over to Michael, I might just sort of mention if everybody can remain on mute just for the duration of the presentation. Michael has left plenty of time at the end for questions, so please keep those locked and loaded. But if you do have a question that sort of makes sense to have it asked during the presentation, if you can put it in the chat, and I'll find a good time to interject. So with that, Michael, thank you very much again, and I'll hand it over to you.
Great, thanks, Ben. Let me just share my screen. Okay, I hope everybody can see that. So thank you, Ben. Look, good morning or good afternoon, depending where you are, everybody. Thanks for the opportunity to present to you today. As Ben mentioned, this topic is gaining a fair bit of interest. These changes were introduced by the government some 12 months ago on the basis that it is a fairly substantial change to this area. So the government gave industry some 12 months to get everything in order. But like all good things, no one really worries about this till the last minute. And certainly in my business at the moment, we're being very busy in looking at contracts, amending contracts, and advising clients in this particular area. Depending on your point of view, though, this is quite a big change from the fundamentals of how we contract, in the sense that it's the old common law notion of freedom of contract. I mean, essentially, the common law position is two people are free to contract on what terms as they see fit. And it's not the role of a government or a court to basically come in and say, well, you shouldn't have agreed to that. But of course, you know, we've seen over the years that various measures by government amending terms of contract. The building industry is probably the biggest recipient of that, all the security of payment legislation, you know, which came in first, you know, late 1990s, early 2000s, you know, regulated payment, regulated disputes, outlawed pay if paid clauses, things like that. So we saw the legislation affecting what parties could contract with in the building industry. Sorry. But this is not new in the sense that unfair contracts regime has been in place for some time. It was initially consumer-led legislation, you know, legislation designed to protect the mums and dads out there. But back in 2016, the federal government expanded the scope of that legislation for the first time to what they defined as small business. And what we have now with this latest legislation coming in next month is an expanded definition of what is small business. The Act works on two premises. Firstly, that a term is unfair. And I'll go through these in a bit more detail, but essentially at this stage, to be an unfair term, it needs to satisfy these three things. The term must cause a significant contractual imbalance. The term must not be reasonably necessary to protect the legitimate interests of the party seeking to enforce that term. And the term must cause detriment to the other party. And the second feature is that there must be a standard form contract. And I said, I'll go through these in a bit more detail. But as we currently sit here, the remedy is fairly toothless in some sense, because if you've got a contract which has an unfair term, then all it means is that that term is void. Void meaning, it's of no effect, can't rely upon it, it's as though it was sort of struck out. But as we'll see, the remedies are going to be expanded considerably. I think for members of ACMA, this legislation is probably going to affect you in two ways. I mean, if you do fall within the definition of what is a small business, you'll have the benefit of that legislation when it comes to contracting with another party. But also, you also need to keep in mind when you engage your own suppliers, your own subcontractors as well, that they might also be small businesses. So while you might have the benefit of the legislation contracting upstream, you'll also need to comply with the legislation if you're contracting downstream. Other thing to keep in mind with this legislation is it is not dealing with the conduct of the parties during negotiation or anything like that. It is dealing purely with the terms of the contract. Often here, in negotiations, people are being unfair and things like that. This particular legislation doesn't deal with that. It's just looking at the contract. There's other forms of legislation that do affect conduct, unconscionability, things like that. So what is a small business contract? So as we sit here today, this legislation applies to small businesses that employ 20 or fewer people, and the value of the contract must not be more than $300,000, or if you have a contract of more than 12 months in duration, the price must not be $1 million. So as we sit here until the 10th of November, that's the current definition of what is a small business. Now, I'm often asked, well, how do I calculate 20 people? What does that mean? And the Act lays out what that test is. So casual employees are only included in that test if they are employed on a systematic and consistent basis. So what does that mean? If you've got a casual employee who comes in every Wednesday, they're included. If you have a casual employee which only comes in, once a month, once every 2 months, only when you need that person, they're not included in the head count. Part-time employees are included by reference to their full-time equivalent. So if you've got someone working part-time for 50% of the week, and another person working 50% of the week, those two together are deemed to be one person, one full-time person. That test hasn't changed under the new legislation. But what has changed, as you can see, is that what is a small business has gone from 20 persons up to 100 employees. So a 5-fold increase, or it's a business with an annual turnover of up to $10 billion. Now that's an OR test, so you don't have to satisfy both of those. So if you tick one of those particular boxes, you're deemed to be a small business to which this legislation applies to. What you'll note is what they've done away with is the actual price of the contract. So under the current legislations, you can see $300,000 or $1 million. That's gone. It's just purely looking at what is the size of the particular contracting entity and whether they're a small business. So those numbers, they're relatively, I think, some people might say, well, that's not a particularly small business, 100 people or $10 million. So you can see it is quite a significant increase insofar as to whom it applies to. I mentioned that one of the key features is that there has to be a standard form agreement. So this legislation doesn't deal with a contract that two parties basically sit down and write from start to finish by putting pen to paper, where you're both negotiating some sort of unique deal. There must be what we call a standard form contract. The thing about that is everything is pretty much deemed to be a standard form contract unless you can prove otherwise. And the way this legislation works, it has a reverse onus of proof. So it deems things to be a certain state of affairs, and it's up to the other party to prove the other way. So most law is the other way around in that, party bears the onus of proof. In this case, it's sort of guilty until proven innocent, if you sort of understand. So when it comes to what is a standard form agreement, the court can look at a number of things up there on the screen. They firstly look at the bargaining power. They look at did the party have a contract already prepared before discussions took place? Was it take it or leave it? What's the opportunity of the party to negotiate those terms as such? Now, I think in your industry, most things are always going to be a standard form contract. You tender for a job, there will, 9.9 times out of 10 be the terms and conditions which will go out to tender. And of course, we have the Australian standard contracts, the standard form construction contracts, standard form supply contracts, those sort of things. I think it's going to be very difficult in your industry to say that there won't be a standard form contract. So for those people, tendering above, then it's more likely than not, you'll be tendering to a standard form contract. To those people, when you're engaging your own subcontractors, if you've got your own standard form documents, then they will be a standard form agreement. From 10 November, there's been some additional tests put into the legislation as to what a standard form agreement is. The first one is whether other parties are required to sign the same document. So, it's not a one-off document. It's the same document that is used for other parties. And the second thing is that if there are any minor, insubstantial or predetermined changes made to the standard form agreement, that will not prevent it from being a standard form agreement. So you don't get around this legislation by having your standard form agreement, adding the word reasonable into clauses or increasing the time limit of something from 7 days to 10 days or anything like that. If those sort of minor amendments are made to the standard form agreement, it's still considered to be a standard form agreement. So I think the upshot of all this is essentially you'll be dealing with what the legislation has called a standard form agreement. What is unfair? Of course, what is unfair is probably in the eyes of the beholder in terms of the view of what one party thinks unfair will no doubt differ from what another party might think. As I mentioned earlier, it's got to satisfy 3 tests. It's got to cause a significant imbalance in the parties' rights. So in other words, one party's got all the rights, the other party's got less, or one party's got all the obligations imposed on them, then the other party hasn't got all the obligations. So there's not an equal balance of rights and obligations in the document. The second thing, it's not reasonably necessary to protect the legitimate interests of the parties who would be advantaged by that term. In other words, does the party need that particular term or not? So, if you don't need it, then it could be considered to be unfair. And the third test is, would it cause detriment to a party if it was to be applied or relied upon? Now, try to satisfy those sort of 3 tests is perhaps in all circumstances not going to be that easy. The one I think will be interesting is it reasonably necessary to protect the legitimate interests of a party? And I think this is where the industry-specific clauses might need a little bit more focus. I mean, safety, of course, is very important in our industry. Environmental protection is very important in our industry. And as we know, it's not uncommon in the contracts, dealing with construction to have, fairly onerous safety clauses in there, fairly onerous environmental clauses. And, there might be a good reason for that, given, the safety legislation, principal contractors, the strict penalties, industrial manslaughter, the list can go on. So the fact you might have what might be considered an onerous safety clause might be justifiable when you're looking at it in a broader context there. The other point is fairness, and it's looking at how transparent the term is. I'll go through shortly just some of the cases, but essentially having the fine print and the clause buried in the back page is something which a court will look at whether it's fair or not. And this is another one where there is a reverse onus of proof. So if you want to rely upon the clause, you have to justify that it does not tick those 3 boxes at the top of the slide there. So the onus is on you to say that it doesn't cause imbalance, that it is reasonably necessary, and that it would not cause detriment. Now, what is not included in an unfair term are terms which go to the determination of price and terms which go to the determination of the scope of work. So you can't turn around and say, oh, I haven't been paid enough here, or the price for the work is not enough. That's not unfair. That's just considered your commercial negotiation. Similarly, scope. You can't turn around and say the scope that I have to perform is unfair. That's just considered part of the commercial negotiation. So we're not looking at price, we're not looking at scope, we're looking at how the contract otherwise allocates risk. Now, what you'll see there on the right-hand side of the screen is essentially an extract from the legislation where it lists examples of terms which may be unfair. And I stress may be because it needs to satisfy those tests on the left-hand side. So the one takeaway I want to give you, if you are looking at contracts, that's the checklist you need to look at in identifying clauses which may be unfair. That's what the legislation has singled out as being the kind of clause. So if you've got a contract and you want to look at it in light of this legislation, as I said, you're looking for those particular clauses which you'll see there on the right-hand side. And some of these are fairly common. I mean, some of these we will see, pretty much every day in most contracts. Clauses which one party seeks to avoid or limit its obligations. Clauses which allow one party to terminate the contract but not the other. We often see, that only a principal or only one party may have a right to terminate but not the other. Clause that penalises a party for breaching a contract. So if there's a trivial breach of a contract, if I use that term, that a clause that makes the consequence of that breach, a significant penalty. Clauses that allow one party but not the other to vary the terms. Clauses that permits one party but not the other to renew or not renew the contract. Clauses that enable one party unilaterally to vary the characteristics of goods or services to be supplied. Clauses limiting one party's right to sue. A clause where one party can determine if a contract has been breached. We often see that clause, if the principal believes that the contract has been breached, then this is the consequence. Those sort of clauses can be unfair. Clauses enabling one party to assign without consent. And a clause which limits one party's liability for the acts or omissions of its agents. They're the sort of clauses, as I say, which you should be on the lookout for. Not saying if every single example of those clauses will be unfair, but they're the kind of clauses which the legislation says might be unfair. Let's just have a look at these. I mentioned that we are at the moment reviewing a lot of contracts. These are real examples I've taken from the ones we're looking at the moment. But the first one up there, this came from a government organisation actually. To the extent of the law, we will not be liable to you as in the contractor, whether in tort or in contract or any other basis in law or equity, for in respect of any loss or damage of any kind whatsoever. So really broad words, arising directly or indirectly from any act or mission, whether negligent or otherwise, on our part or on any part of our employees, agents, contractors or subcontractors in connection with or relating to this agreement. It's probably the most unfair clauses I think I've read. I mean, it is extremely broad. It's basically saying we can do whatever we like and we're not liable to you. If we go back against my checklist there, you can see it ticks the first box, enables one party to avoid or limit their obligations. It ticks the box there about the final one. It limits one party's vicarious liability for its agent because it says it doesn't matter if it's an agent or not. And it limits one party's rights to sue the other because it's basically saying, well, you don't have any rights to sue me under this clause. Not surprising, we've recommended to our client that they delete that clause. Another example, so we may in our absolute discretion at any time cancel all or any of the works, goods or services covered by this agreement which are yet to be delivered or provided. Upon receipt of a cancellation notice, you must cease the works, to manufacture the goods or provide the services and mitigate your costs. A broad clause, but not an uncommon one. As I said, it's essentially a termination for convenience clause. We may at any single time terminate this contract. Now, in isolation, you'd say that's quite unfair because it doesn't give you certainty. It may not be unfair if the clause then goes to spell out what the implications of that are. So on those circumstances, we will pay you, for work done to date, we will pay you cancellation cost, demobilisation, etc. So it's necessary to look at the clause in its entire context, but it's an example where, going back to the checklist, and it's the second one there, enables one party but not the other to terminate the contract. Indemnity clauses, and I've taken this from a case involving the company called Servcorp, who run those serviced offices. And the court found that this particular indemnity clause was unfair because it said, with the exception of the gross negligence or willful misconduct of Servcorp, the other party shall indemnify Servcorp, its employees, its caretakers, cleaners, agents, or invitees against any theft or loss from the office or damage to the office and its contents attributable to the client, howsoever occurring. And the reason that was held to be unfair was basically it was not fault-based. So the client had to indemnify Servcorp for things it hadn't done or things it hadn't caused. It just had to indemnify Servcorp for whatever damage happened unless Servcorp was grossly negligent or committed willful misconduct. And it said the court found, when looking at all those factors I went through, that that was an unfair term. So sort of be on the lookout for those. If indemnity clauses are in every single contract I think you will come across, but if you are indemnifying a party, then make sure it's an indemnity for something you have caused, that it's not, you are not indemnifying for something you haven't caused or something beyond, beyond your control. Could I then just go through a few other case examples? When the 2016 legislation came out, again, the industry was, a fair bit of talk about it, but really the remedy, as I mentioned before, essentially was going to court and getting an order that the clause was void, was not very practical. So what happened, and I suspect what will happen in practice again, it's really the ACCC taking on these cases, trying to single out industries or single out particular common areas where there's often these unfair contract terms. And so they picked on, in 2017, the waste industry, and a contractor familiar to some of you will be JJ Richards, privately owned waste management company in Australia. They have about 3,500 customers, I understand, ranging from the big, government down to just the small businesses who, collecting one or two bins. But essentially, the court found pretty much all of their contract was unfair and declared it void. JJ Richards basically agreed with that, and so it was sort of declared void by consent, with JJ Richards having to go back and redraft its terms on something a bit more balanced. So what did they find was unfair? The first one was essentially that the contract went on forever unless the other party gave notice to cancel it 30 days before the end of the term. So if you had a 2-year term, you had 30 days before the end of that 2 years to give notice to terminate. Otherwise, it went on for another 2 years. And then if you didn't give notice at the end of that second 30 days period, went on for another 2 years. So you had a contract that might have been 2 years. You failed to give notice, it just kept going on and on. That one got struck out. The second one was just a right at any time to increase prices. So there was a right in the clause, there was a clause in the contract which allowed sort of a usual CPI increase, but outside of that, there's also an additional clause which said JJ Richards could increase its price at any time. That one was again considered unfair because it only operated one way and it didn't allow the other party to get out of the contract if it didn't like the increase in the price. You just had to lump it. It also prevented, JJ Richards was not liable in any way if its performance, if it couldn't perform the services. So it essentially excused itself from liability if it was prevented or hindered in any way. If JJ Richards could not render the services, then it still charged the customers for those services, even in circumstances where the customer wasn't the cause of why JJ Richards could not render the services. So there was some totally unrelated cause. JJ Richards didn't empty the bin. The customer still had to pay JJ Richards as though it emptied the bin. Granting exclusive rights to remove waste, the court said was unfair. Allowing JJ Richards to suspend its services but continue to charge the customer if the customer was late in making payments. So the court held that was a penalty because, yes, there'd been a breach that the customer not paid, but there was also not only were you having to pay more, but you weren't getting the service. So there was a double penalty there. And there was an unlimited indemnity in favour of JJ Richards. And there was also termination payments as well paid. So as an example where essentially I've seen the contract in that particular case, it's just a one-pager, and essentially all of it got the red pen taken to it by the court. The other thing the court also said that's unfair was the lack of transparency in the contract. So the other thing this legislation looks at is making sure that the terms are transparent. Hasn't been drafted in a plain English way, or hasn't been drafted in the most complex legal language that the ordinary small business person wouldn't understand it. Hasn't been presented in a manner that's clear and readily accessible. The courts were very much on were the terms and conditions apparent to a person when they entered into the contract. They looked at the font. The font was too small for anybody with reasonable eyesight to read, so that was considered a lack of transparency. And as I said, there was basically everything was on one page in very small font. So in this case, so the unfair terms were not presented in a way that drew them to the customer's attention. So yeah, not the best day out in court for JJ Richards. I mean, they were probably the first. I think they were the first. I might be wrong. That was actually brought under this when the legislation came in 2016, and there was a fair bit of, not surprising, a fair bit of talk and controversy after that decision, about it. The ACCC then went after a security firm, and one of the examples in 2020 involving ADT Security, or Tyco, was the ability of Tyco to essentially unilaterally just amend the terms on 30 days notice with no right of the customer to terminate. So enter into a contract today, the following day Tyco gives you notice, look, we're changing the clauses in 30 days. And the customer had no right to essentially terminate if it didn't like those new amended terms. So that was held to be unfair. And if you did get out of the initial term in such a way, there was also a requirement to pay some fairly large exit fees. And in the end, Tyco agreed to refund customers, for some of those exit fees which it had taken, and amend its terms. And the final example, showing that no industry escapes this, is the funeral industry, where Bauer and O'Day, and this is only last year, the ACCC brought a case against them where they essentially had the unilateral right to vary the price without seeking the customer's consent, and with no right for the customer to terminate. So what we are seeing to get around that sort of thing is it's perhaps not uncommon to see a clause which allows a party to increase their price, for certain reasons. But you do need to give the other party the ability to get out of the contract if they don't like the price, because if you've entered into a contract at a price and then a party has the unilateral right to vary that price, then it's unfair just to impose that price on somebody without giving them that right. So, but that particular clause in the funeral contract did not have that. And the second provision, which was found to be unfair, was essentially a double dip that customers that didn't pay their invoices on time both had to pay interest of 10% per annum and a late payment fee of $352. Not a lot of money in the scheme of things, but essentially they couldn't justify why they needed both of those particular things there. So look out for what are the consequences of a breach. You know, is it a penalty in the sense, you know, the party's being penalised because of a particular breach. So as happens with all of these cases, once the ACCC brings the proceedings, the other party puts its hands up and admits, and that's what happened in this particular case. And they were fined only a fairly small amount, as you can see, some $26,000. So there's some examples, and there are other examples, and I suspect there will be even more examples when the new legislation comes through, you know, of the ACCC taking a fairly interventionist approach, you know, to try and look at these terms. I'm not aware, and I'll stand corrected if they've sort of gone after people in construction and supply industry. I dare say there's no reason why they won't, but so far they've sort of kept it in some of these more sort of broader sort of industries. So what's changing from next month? New prohibitions, broader scope. I've spoken about new penalties. What won't change is what is an unfair contract term. So that still remains the same. And what won't change is what is the definition of a standard form contract. That still remains. So just revisiting just the changes in terms of the scope of who it applies to. So again, as we currently sit here today, it's 20 people. Is a small business. That's going up to 100 people, or a business with a turnover of $10 million. The current test today does not take turnover into account at all. It's just purely on a headcount basis, but under the new regime, you can see it's one or the other. And the upfront contract price test, which applies today, won't apply in 1 month's time. The value of the contract, be it $1,000 or $1 million or $10 million, it won't matter. It's just simply, are you a small business insofar as those tests are concerned. So prohibitions then. So under the current legislation, as I've said a couple of times, all that can happen is that clause is declared to be void. So of no effect. Essentially, the red pen just crosses it out, and that's basically it. Now it's an offence. So now, if you have an unfair contract term, you're in breach of the Competition and Consumer Act, and it's an offence also to actually propose and enter into a standard form contract that contains an unfair term or seek to rely on an unfair contract term in a standard form contract. So it's the entry into by actually having it there in your standard form that can be an offence, and when you come to rely upon it, that can be an offence. So pretty much capturing every stage of the transaction in reality, from the beginning to the performance. But the penalties have increased quite substantially. Under the current legislation, there's no fines or penalties. It's just, as I said, a void. The penalties now for having a contract which has an unfair term or relying upon an unfair term is the greater of $50 million. This is for a corporation. Individuals can have penalties as well, but the ones on the screen are for a corporation. So $50 million or 3 times the value of the benefit obtained. I think that's the benefit of obtained if, relying upon, say, one of those penalty payment provisions. Or if they can't determine the value, then it's 30% of your turnover during the breach period in which you were relying upon that. So when the period in which you're relying upon your term, you can be penalised 30% of your adjusted turnover. And the Act does go into how you calculate that. I won't go into it. It's more of an accounting sort of exercise. They're quite substantial, I think, as you can see there. To go from no penalty to in 1 month's time have a penalty of up to $50 million sort of shows the seriousness of which how the legislation has taken that. Will we see penalties of $50 million from day one? I suspect unlikely, unless it was a fairly serious breach, but they are quite substantial, as you can see. So come 10 November, it will apply to new contracts entered into after that date. If you renew an existing contract, so there's an option to renew, your option will be covered by the new regime. And if you vary an existing contract, so you enter into a deed of variation to add some terms, those terms which are varied will be caught. The underlying contract won't be because it was entered into prior to 10 November. But if you vary a contract, then the variation will be caught. So very broad. Essentially, the only thing that's not going to be caught is a contract entered into prior to 10th of November 2023, which won't be renewed or which won't be varied. So what's that mean? I've taken these tips directly from the ACCC, so I thought let's see what they say you should be doing. As I said, for you as members, it probably applies both ways. You'll have the benefit on the upstream, but you'll also have the obligation on the downstream, and you're engaging suppliers as well, or contractors. So consider both points of view. If you think a term is necessary to protect your business's legitimate interests, consider the term from the other party's point of view. This is about balance. One of the tests is it balanced? And as I said earlier, there might be a good legitimate interest why you need a term. So, safety examples, performance guarantees. There could be reasons why you need a particular clause. Consider counterbalancing your terms. By that, I mean, if you've given yourself a right, then should the other party have a similar right? So if we look at termination, if one party can terminate a contract for, the following 3 or 4 events, should the other party have a similar right to terminate the contract for those same events? The Australian standard contracts are reasonably balanced in that regard, but, if they're modified, or most specifically drafted contracts normally have termination rights only applying one way. Avoid broad terms. Don't have terms that are broad as possible. Make sure they're only as broad as reasonably necessary to protect your business's legitimate interests. So, often, and we try and cover the field, make these terms as broad as possible, but the court can find that it's going beyond what is necessary for your legitimate interests. You can't contract out of Australian consumer law, so any clauses seeking to limit the other party's rights and things like that aren't going to be enforceable. Be clear, use clear and simple language in your contract, and be transparent. So the decisions to date have been fairly scathing of the fine print, where you've got to, not so much where you've got to go to a website to find terms and conditions, that's not uncommon, but not being transparent about where to find those terms and conditions on a website, not having those links clearly stated, things like that. So they're the things. I suspect, as I said, for you dealing with contracts which you receive, from head contractors and principals and the like, I'll just sort of draw you back to that checklist I mentioned earlier on in the presentation about the example clauses, which the legislation said, might be unfair. So I think you should be looking, at contracts you enter into in that light. And if your own contracts downstream have those clauses in them, again, probably just being alive to. It is going to be difficult, I suspect, because, the hard question is, well, how do I know if the party I'm dealing with has 100 people or not? or a turnover of $10 million, I suppose you just have to ask the question, because the onus is going to be placed on you if you're the party contracting with the small business to justify why it is you need those particular terms. That's all. Actually, I want to say from just the formal presentation. Appreciate a little bit of detail there, but I'm happy to answer any questions or the like.
Thanks, Michael. I will sort of turn it over to everybody who's attending today to see if there are any questions, but perhaps sort of just to get things moving. It's not so much a question as it is, I guess, seeking your opinion on something. One of the things that's sort of been raised with the AMCA with this legislation coming out is that you might have subcontractors or specialist contractors that are AMCA members that aren't themselves protected by the legislation because of their size, but are exposed to the legislation in terms of the protection it affords their specialist contractors. Have you sort of got any views on that? That's something that us and other parties, I guess, have sort of been raising with the government throughout the consultation process for this legislation being written.
So Ben, you're saying you might have members who aren't caught by that small business definition?
Yeah, so they're big enough to not be protected, but obviously exposed to having their subcontractors and specialist contractors. So I guess the onus is really just on the business to dot the I's and cross the T's, is it?
Yeah, well, that's right. I mean, I suppose there has to be a cut-off somewhere as to what is deemed to be a small business as opposed to not a small business, which is what the legislation's done. So I think it's done a fairly big, by taking it up to a $10 million turnover. But yeah, those particular companies just need to be alive to who they're contracting with their suppliers, to them, because, more likely than not, they're going to be dealing with people potentially who are caught by that definition. So they need to be alive to what terms they're putting out into the market, because you'll be caught by that. You're not going to be caught upstream because the government's made a decision that it won't apply to you because of your size upstream. But downstream, you will be caught depending on who you're contracting with.
Sure. I've got a question here from the chat, and I encourage anybody else who has a question, if they feel more comfortable putting in the chat, I can ask it on your behalf. This question comes from Phil Peacock at AG Coombs. Does the regime apply to state/government entities, as it's not unusual for such entities to contract on a take it or leave it basis, notwithstanding the contract might contain unfair contract terms? That's a good one. We'll get one regularly. Michael,
it is a good one. Short answer is the Trade Practices Act doesn't, what the Competition Consumer Act doesn't, because it's Commonwealth legislation. And insofar as an ordinary procurement activity of government's concerned, the answer is no, it does not apply. Insofar as government is carrying on a business, it will apply. And the reason for that, it says constitutional. So if a government's just going about its day-to-day activities of, building things, then no. But if you've got a corporatized government entity, like say it's running an airport or it's, running a commercial venture, then it does. There is, however, state-based sort of fair trading legislation, which generally mirrors the Commonwealth legislation, and that can sometimes expand the scope of it beyond that. I'm not 100% sure what the states are doing. The states have to date generally mirrored the legislation, but at the Commonwealth level, as I say, unless they're carrying on a business, they don't get caught. Which I appreciate what Phil's saying, because some of the most onerous contracts you'll see are published by government.
Yeah, thanks, Michael. I guess, also a lot of governments, both state and Commonwealth, are sort of introducing procurement processes that are trying to provide opportunities for smaller business as well. So I guess it really is a case by case basis. If there aren't any more questions, I might just sort of see if I've got a couple others I can throw at you. One of the ones I had for you, Michael, actually would be if you suspect that your contract, for example, with the builder contains unfair contract terms, how would you suggest going about raising that? Is it just around clear and transparent conversations as soon as possible?
Yeah, I've already seen it, Ben. We're already just seeing, some people just saying, look, this clause is unfair as it provides a unilateral right to one party to terminate. We believe it should be struck out, amended, or whatever the case might be. I am finding people aren't afraid to, use the legislation in terms of raising it with, with counterparties. So I think you just, just simply refer to it. The thing you've got on members and everyone else has on their side is, as I say, the legislation actually gives you those examples. So it's quite easy to make the statement with some substance and basis by saying, well, this particular clause, could be unfair.
Still no other questions, so I might just take the opportunity to ask mine if that's all right. So I mean, again, this is sort of around sort of hypothesizing a little bit, but Michael at the moment is representing AMC and our members on the standards committee that's reviewing the general standard form of contracts. Do you see this legislation changing, I guess, the way that those standards are written going forward?
In its unamended form, the AS contract is, I think, reasonably balanced in its unamended form. Now, I know it gets changed all the time. The charter of the current committee was not to change the underlying risk allocation. So there's been no change in the latest draft, which we're discussing tomorrow, incidentally, to change the risk allocation in how the unamended Australian standard is drafted. So I don't think, Ben, it will change that document as published. What it will do is maybe look at what amendments are made to that document to essentially change that position. I think there needs to be greater care taken, and rather we just go through and amend the Australian standard to change the risk allocation without taking account of this legislation if you know you will be contracting with those small business. I think that will by necessity have to change given the potential penalties that apply.
Thanks, Mark. We've got another one from Phil. For an entity who starts a tender process by introducing a standard form, are there any indicative behaviours or communications that might indicate that the entity is not issuing the contract on a take it or leave it basis?
Yeah, I think I said earlier, I think it's going to be very, very hard to avoid being a standard form. If you go out as part of your tender package with a document, it's going to be standard form, despite the fact even if you ask for contract departures, which you'd probably need to do. You'd rather than just take it or leave it. If you've got any departures to the contract, then please let us know. Even that, the legislation says if those departures are minor and inconsequential, then it doesn't change the fact that it's not a standard form. I think personally it's going to be very hard for it not to be a standard form. I mean, and you wouldn't go out to market with nothing and say to a party, "Oh, let's sit down, the two of us, and negotiate a contract from scratch." But you almost have to get to that stage for it not to be considered a standard form, because one of the tests is if one party produces the form and one party provides that form as part of its tender. So I think either you start from scratch or the document you finish with is so radically different from what you went out with that you could prove that it was evenly negotiated, then you might have an argument to say, well, yeah, we went out with this, but this is what we ended up with because we all sat down and worked it through, whether that would happen. So I think it's going to be difficult.
Thanks, Michael. I've got a good one here from Samuel Gretsch, who raises it in relation to the point that I raised before, where a contractor might be too big to be protected from builders, but maybe subcontracting or dealing with a supplier who is protected. Could we rely on the head contract terms as reasonably necessary to protect legitimate business interests of the party?
Yeah, I understand. Yeah, that's not a bad question, is it? Can you say that it's reasonably necessary because if you don't fill your job, then I'm going to be in breach of my head contract? It's an argument, but just remember it's a reverse onus argument that you've got to satisfy, because the starting presumption is going to be, if a clause is in there, which is otherwise unfair, the presumption is going to be that it's unfair. That's one test. The other test, of course, is that is there a significant imbalance as well? So you need to look at, is the contract otherwise balanced? Is that clause reasonably necessary as well? And then you need to look at the entire contract as a whole, if you know what I mean, like looking, it's not just singling out one clause in the whole lot if you can look at it. So I think it's an argument. I think, yeah, but I wouldn't be putting all your eggs in that basket, I suppose. I think there could be a risk with that, which does place you in a difficult position. I understand what you're saying, because you can be assuming some risk at the head contractor level, which you may not be able to pass down to the subcontractor level. But I think you probably have to take a bit of care with that one.
Thanks, Michael. I haven't got any other questions at the moment, and I'm pretty much out of them myself, but I guess I probably know the answer to this one, but I'll just pose it anyway, is that, I think heading into this, at least for me, I've been really thinking about construction projects, given some of the terms that we see in specialist contractors' contracts. But obviously all this applies to service and maintenance contractors, of which we've got many on the call today and many in our membership. So all those things should equally apply to those types of companies.
Yeah, goods and services. So it applies to goods and services. Yep, correct.
Okay, well, look, if anyone does think of any questions after today's session, please feel free to send them through to me. I think, given the impact of this legislation, there are some further things that AMCA can do to support members. And I guess as this stuff gets tested over time, we'll learn more about how it gets applied. So we'll continue to work with Michael and McCullough Robertson as we learn more about the way that this articulates. Michael, can I just thank you again very much for your generosity, not just today, but as I mentioned before, Michael gives up his time to represent the AMCA on the Standards Committee and has presented to us and our members many times. So we really appreciate your generous support.
Thank you.
Thank you to everybody else for joining us today. Hopefully you found this of some benefit. And like I said before, if you have any other subsequent questions, please send them through and we'll do our best to get some answers for you. Yep, I hope you have a pleasant rest of the day.